Domestic Violence Laws in New York, Part 2, DV Case Overview, by New York Defense Attorney Andrew M. Stengel. New York Domestic Violence Criminal Case Overview. When charges involve allegations of domestic violence or DV, the most commonly asked questions include: what is allowed and what is prohibited by order of protection, and can it be alerted? Will the cooperation or lack of cooperation of a complaining witness or other witnesses affect the outcome of a case? What are the possible outcomes of dispositions of the case? DV cases, orders of protection. During a criminal case that involves an allegation of domestic violence, an order of protection signed by a judge will typically be in effect during the pendency of the case. A violation of the order of protection may result in an arrest and criminal contempt charges. When a person is charged with an alleged DV-related crime, a judge will typically issue an order of protection to protect a complaining witness against future acts by the person who is charged with the crime. Some states call this a restraining order. There are two types of orders of protection associated with criminal cases. Family court judges may also issue orders of protection separately from criminal cases. A full order of protection and a limited order of protection. At a person's arraignment, the order of protection will be signed by a judge and will typically be in effect for 6 months. If the case is still pending after 6 months, the order is typically to be extended for another 6 months. As long as the case is pending, it is highly likely that the order of protection will continue to remain in effect. A full order of protection bars contact of any kind, whether in person or electronically, and contact via third parties. That means that the person charged cannot go near the protected person's home, office, or school, and may not make contact by phone, text, email, on social media, or any way imaginable. Third-party contact bars anybody contacting the protected person with messages from the person charged. So, even a friend of the person charged may not make contact with the protected person to pass along a message. A limited order of protection only prevents the person charged from committing a crime against the protected person, which is also included in a full order. That may be common sense, but when there is an order in effect and there are allegations of a crime committed against the protected person by the person charged, the crime of contempt is likely to be charged. It is rare for an order of protection to be completely dropped or altered while a case is ongoing, even if the complaining witness asks for the change. If the person charged and the complaining witness have a child in common, family court may modify the order of protection for visitation and custody. This is not automatic. It requires a petition filed in family court. If children were present when the charged crime was committed, they may also be named as protected parties in the order. DV cases, the complaining witness. The total cooperation of a complaining witness is not always necessary to prosecute a domestic violence case, though every case is different. However, it is important to note that compelling a witness not to cooperate could lead to criminal charges of witness tampering and criminal contempt. When a person is arrested for an alleged DV crime, often the complaining witness may have second thoughts about a loved one, or at least a relative, being arrested. Assuming the police make an arrest in a DV case, that does not mean a prosecutor will go forward with the case. In some counties in New York, a prosecutor will not charge a person with the crime if the complaining witness says, "I don't want to press charges." In such cases, the prosecutor will issue a declination to prosecute. In other counties in New York, the prosecutor will forge ahead with a DV case after an arrest, even if the complaining witness says that they do not want to cooperate. After an arrest is made and one or more misdemeanors are charged, a prosecutor will usually call the complaining witness and ask them to sign a supporting deposition. Felonies are treated differently because they involve the grand jury. If a supporting deposition is not signed within 90 days of an arrest, it is possible that the case will be dismissed and sealed. That is due to speedy trial time for a Class A misdemeanor, which is 90 days. However, there are two important ways that a supporting deposition may not be needed to prosecute a DV case. First is if a complaining witness, victim, writes and signs a domestic incident report, and there are enough allegations to make out some or all of the charges. Second is if the prosecutor files a new complaint, called a superseding information, usually with excited utterances of the complaining witness, victim, often heard by law enforcement or a civilian witness, to make out some or all of the charges. In either case, it merely means that a case will go forward beyond 90 days. Proving a case at trial with a non-cooperating complaining witness, victim, is a different matter. In other cases, a complaining witness may change their mind down the road during the pendency of a criminal case. The decision of a prosecutor whether or not to continue a case after a complaining witness ceases cooperation depends on a number of factors. First, the presence of any DV history between the two parties and any known DV or criminal history of the person charged. In New York, when police are called or a complaint is made related to domestic violence, whether or not an arrest is made, the incident report is kept on file years after an arrest. Second, a prosecutor will consider such things as the allegations in a case, for example, if there is an injury, and if so, how severe it is. The paramount question for a prosecutor is if he or she can prove the case beyond a reasonable doubt at trial. If the answer is no, then the prosecutor has an ethical obligation to dismiss the case. Even if a complaining witness decides not to cooperate post-arrest, if the speedy trial time has not run out, a prosecutor may still be able to prove a case beyond a reasonable doubt at trial. Other witnesses, 911 calls, and statements to police by the complaining witness, known as excited utterances, may be admissible at trial to attempt to prove the allegations. DV cases, plea bargains, and sentencing. If a person is accused of domestic violence-related crime, that does not mean that a case will result in a permanent criminal record. All people charged with crimes, DV allegations included, are presumed innocent until proven guilty beyond a reasonable doubt. If the person charged lacks a criminal history and/or a history of similar allegations, and the allegations underlying the charges are not severe, then it is possible that a skilled and aggressive defense attorney may be able to convince a prosecutor to dismiss a case immediately or in 12 months, known as a family adjournment and contemplation. It may also be possible to convince a prosecutor to offer a non-criminal plea bargain, like disorderly conduct or harassment in the second degree. Both are violations and are not crimes, and while a disorderly conduct conviction eventually seals, a harassment conviction may not be sealed. In many cases, unless a case is dismissed or a person is found not guilty after trial, there will be conditions attached to a plea bargain or a recommended sentence. Those conditions include continuing to obey an order of protection for a period of years. Even if a case is resolved either by guilty plea or conviction after trial, violating the order of protection may lead to new criminal contempt charges. Additional conditions of a plea bargain may include a therapeutic program to address domestic violence. Failure to obey all of the conditions of a plea or a sentence, including abiding by the order of protection in any court order, could lead to the imposition of a jail sentence. As a domestic violence laws in New York, Part 2, DV Case Overview, by New York defense attorney Andrew M. Stengel. New York Domestic Violence Criminal Case Overview. When charges involve allegations of domestic violence or DV, the most commonly asked questions include: What is allowed and what is prohibited by order of protection, and can it be alerted? Will the cooperation or lack of cooperation of a complaining witness or other witnesses affect the outcome of a case? What are the possible outcomes of disposition?